November 7th at 6 p.m. in the jury assembly room. I am Councilmember Berkeley Allen, and we are picking back up where we left off in the spring, hopefully to make some changes to policy, to the website, to some implementation, and if there needs to be legislation, then we'll get that prepared for the council to deal with. So real quick, we'll just do introductions in case anybody's listening at home and wants to know who's on the committee. So John, we'll start with you.
John Dotson. I'm a broker at Parks and a member of the Board of Directors of Greater Nashville Realtors.
Great.
I'm Joey Hargis, the Metro Zoning Administrator.
All right, I've already introduced myself.
I'm Bonnie L. McBroom. I'm the short-term rental property chief at Metro Codes.
I'm Brett Withers, Metro Council.
Deborah Volley, short-term rental owner and realtor at Village.
Gotcha. Awesome. Thank y'all for being here. We may be joined by others who are looking for the right door to come in, and we'll welcome when they arrive. So we met back in the spring, and I think have touched on almost all the topics that we're going to go over tonight. Mr. Hargis has created some proposed legislation that we'll look at, and we'll review the items that we did. And I apologize that I did not print the minutes again. So I'll send those out when I send out the minutes from tonight as well. So I have this listed next as report from codes and community groups. And I will just say I have heard a few things from the community, so I will bring those items up. Some of this sort of would count as new business. And I would ask for input from the body, and Councilmember Withers, I will say right now, I need you to sit both in the seat of a council member, but also representing community that does not own short-term rental, because this group has been great, I think, at looking at all viewpoints, but I want to make sure that viewpoint is articulated tonight. So we just went through introductions, so if you'll punch your button and quickly tell the world who you are.
Hi, world. I'm George Rill. I'm the managing broker of Compass and the chair of the Greater Nashville Realtors Legislative Committee.
Gotcha. Thank you. So two issues that have come to my attention. One, I think GNR talked about last night, was about the HPR regulations, and I think I did not describe them accurately to you, John. So I had a neighbor, a new Nashville resident who had gotten caught in a bind because her understanding was that if she lived in her home, could get an owner-occupied short-term rental permit. And then when she went to codes, discovered that Nashville has this crazy thing called 2 homes on one lot is a duplex. And she didn't even realize she had bought half of a duplex. So she learned about our HPR regulations the backwards way, and that if you only own one of the homes on an HPR, then you are not eligible for an owner-occupied short-term rental permit. You have to own both of them, and then you can have an owner-occupied for the one next door because you'll be there to keep an eye on it. So I think that's more of a clarification than anything else. I'm not sure that that's something that we have been asked to revisit, except that I would beg the real estate community to do your best to stay on top of these laws, because this person's in a world of hurt. Because her finance plan was counting on that income, and now she's found that that's not a possibility for her. So I'm not asking this group to go back and revisit that regulation. Just wanted to point that out. The second one was I did have a request from a potential owner to revisit the allowance of more than 4 bedrooms, and I will say, when we looked at other cities back in 2015, writing our legislation, 2014, I think we actually started, there was a range out there of the few cities that actually had thought at that point and had written regulation. And some of them were as low as 3, and some of them were unlimited. And we, at the time, settled kind of, in a sideways fashion on 4. And then initially, actually, when we first wrote the legislation, it was 3, which is the same as our historic bed and breakfast were. 3 rooms and 6 people, two people per room. And it's possible we would have avoided a lot of our party houses had we stopped at that. But at that point, most of the attention that was being paid was from people who had a wider vision, and one, what you said, what about corporate retreats and family reunions, and shouldn't it be a bigger number? So at the time, 4 seemed like a compromise based on other things I was hearing, and we looked at 2 per room plus 4 more, which came from another city. And that's how we've ended up with the 4 rooms and the max of 12. My experience has been that for the problem properties that we are aware of, and I will acknowledge that it is probably a small number, like many things, it's a small but very visible or vocal number. Mostly they have come from larger ones. And so I would just in fairness to the person who made the request, why was it 4? Do we really need to stay there? If they're big lots, would 5 bedrooms be okay? I will, before I issue my opinion, I'd love to have feedback from other members of the task force just on if that's something that we would at least begin a discussion on. I don't know that that's something that I am ready to have happen soon, but I would like to hear what thoughts other people have. And I'll go room in the call on you if you.
Does that restriction apply to owner occupied?
Currently, the restriction for both owner-occupied and non-owner occupied is a maximum of 4 bedrooms, sleeping rooms is the language actually, in the house. It can't have more than that.
Okay.
And that has kept us from having a 10-bedroom house become a mega hotel, which is a nightmare, I think. So yes, it applies to both owner-occupied and non-owner occupied.
I don't know that there's appetite to revisit that. I wouldn't personally think it was necessary to revisit. I understand why someone would want to, but I think that would open a can of worms that we would not want to open, personally.
I think that's a valid observation. Thank you.
And is it that someone wants to increase the number or reduce it?
Increase.
Oh, wow.
Increased. Certainly it's potential for more income, but I think we've provided plenty of potential for income here.
If I might comment.
Yes.
There are situations where it would be tenable. There are some situations where it would cause bad problems where they already exist. I'll give you an example. We have condominium units that are built 4, 5, 6, 8 units, and the majority of them or all of them become short-term rental properties because they are in zones where not owner-occupied permits are obtainable. And so you can see with a 4-unit and 4 bedrooms in each, you're looking at 48 people at any given time. So you just compound that problem. But then there are places where there are large houses on large lots where perhaps it wouldn't be an issue to that extent. However, delineating that in an ordinance would be probably very difficult.
And I will also point out that we do have a bed and breakfast homestay and a historic bed and breakfast inn that do allow for larger numbers if you qualify for that. What had been proposed, I believe, was still limiting the number of people and requiring a large lot but allowing more bedrooms. But it still seemed to me important to have a very definite line on the size of house that could be used for this. So
Now,
Go
if
ahead.
it was for the same number of people that, and someone had a 5-bedroom house and so a max of 12 would make sense, I could see why someone would want to do that. But again, I don't know what the appetite is for really any new legislation regarding STRs, so.
And I will say, I think verifying the number of guests is one of the things that we have least control over. So.
The only real control that we have over that is just keeping an eye on the advertisements, and then also the reviews that are put on the advertisements. A lot of times we can pick up pretty easily if they're exceeding their permitted limit on number of people. Gotcha.
Good point. And if they do exceed, is that something that we, under state law, are now allowed to cite them for?
If they advertise excess, definitely. And we've done that since day one. And if we have adequate number of reviews where the person, where the reviewer states clearly that they had 14, 16 people and they're permitted for 10 or 12, we absolutely cite those, yes.
Good to know.
But you can see that that's rather a time-consuming ordeal to comb through those advertisements and reviews.
Right. Okay, that's good information as well. Okay, that's helpful to me. I'm gonna make a note of that as helpful comments, and then move on to another question that I had. I think I don't have the right people here to go into this very deeply, but I was speaking with another council member who asked again about the possibility of having more, the word we've been using all along is enforcement, and just the fact that we are hampered by our limited resources to do any kind of enforcement nights and weekends, which is when most of the violations happen. But a council member pointed out that it would be almost as useful and almost as valuable simply to have someone who would simply document, that we don't necessarily need them to get out of the car and knock on the door and tell people to be quiet. The police will do that in situations where they can, but the police generally have a difficult time following through with the documentation that makes it end up on the short-term rental documentation that we need. So I believe that the council member and I can perhaps go back to Mr. Hall and ask if there's a possibility simply of having the flex team or someone be more willing to at least drive by and document, yes, there was noise from this house, on Friday night at this time, and have an official documentation that was happening, because that's one of the things that we're missing. So I'm throwing that thought out there. That again doesn't require any kind of change to legislation or to the website, but I think it's having it framed that way for the first time, just as documentation as opposed to enforcement, I think might open up a possibility there. So I'm going to ask if you'll join me in making that request. So.
Can I ask a question about that?
Yes, you may.
So are you seeing that as an incremental step toward having actual enforcement of the regulations?
I think we started the wheels turning this year in the budget process to try to get funding available for some nighttime codes enforcement. But there hasn't been a successful model that has been put forth where you've got a codes enforcement component who understands what the issues are, as well as a security and safety component, which would be a police officer probably, to ensure that we're not putting a codes enforcement officer into a situation that he's not equipped to keep himself safe in. And so right now, figuring out, do we have one person who is somewhere in the middle and we try to send them all over all 525, square miles of the county? So we didn't get far enough along in figuring that out for either the police department or the codes department to feel comfortable with what we were asking them to do. So I would say, yes, we've asked that question. We've asked them to spend this year looking at it. And I think that it's not outside of existing budget stuff to simply ask a flex team to spend some time helping us with that piece of it. I think it'd be a small step, but that and also having gotten it on the budget discussion this year may make that happen better as well. If there are other tools that y'all can think of, I mean, that's.
No, I understand what you're saying about not putting a codes person in a situation where
Right.
they might be in danger, and that I can see that happening. What we hear is the cops come out and say, you guys need to turn it down.
Right.
And it's quiet for 15 minutes, and then the party resumes. And what you just said about the challenge for having the police document those things, okay, it would be good to have them documented. It also seems like what the most effective thing is, however we get there, is that if somebody comes out and it's noisy, that there is something that is done effectively to quiet it down, get people back in the house,
Right.
get their clothes back on,
It's very important to do both, though, because, you know, if the neighbor next door every single weekend has to call the police, and the police are nice and they come every single weekend, but it's 50 weeks a year, then we haven't really solved that problem for the neighbor. But if we can get the codes people to come, you know, every other weekend and document, yes, that was, then, you know, that's 3 violations that are documented that you can take to environmental court, and get the owner's attention, you know, that you need to come up with a better system. Mr. McBroom is, we've talked about the implementation of, for repeat noise offenders, requiring the noise monitors in those properties. And I think we decided, rather than putting that into the legislation, that's something, when he goes to environmental court for someone who's been noisy on a repeated basis, then that's a relief that he can ask for from the judge. So, but again, it's important to have either, often neighbors are not as comfortable showing up in environmental court. So if we can add another possibility for getting that documented, that may provide us another tool. So that's kind of my thoughts on the where we can at least move forward on that piece of the enforcement. I welcome other ideas. You know, if there's a way to get funding out of this that pays for private businesses to do it, but that won't be cheap. So just a thought on that one.
Councilman Brown, I mean, from a codes enforcement standpoint, I mean, a noise ordinance violation is a codes violation regardless of who's committing it. And so I guess one of the things about it is that there can be any number of residences or businesses, for that matter, that commit noise ordinance violations. And would this staffing complement be specific to short-term rentals, or would that person also address lots of other noise violations speaking as the representative of the 5 Points area, that like that. I've got any number of businesses that have noise ordinances on a pretty recurring basis. And so like, is that going to be the mechanism for handling those, particularly in the evenings, which is usually when those occur?
Yeah, that's an excellent point.
You know what I mean?
As I've
Or is there
said,
gonna
I
be
don't
specific
have
to
the right,
STRs?
I don't have the right codes member. That would be the director to answer that question. So we'll have to ask him after this meeting. But I think you raise an excellent point. And again, I think all of those, getting them documented is helpful. I think different departments have different skill sets to handle different pieces of it. And I think the codes people have the ability to say, this is a restaurant, they're not supposed to do this. I'm going to make a note of that. But this is a house, and I know how to look it up and see that it's a short-term rental. I'm going to document that. So again, I'm just throwing ideas out there.
Yeah, and I mean, like I say, for businesses, I do have neighbors that complain about noise, especially from amplified music from restaurants, sometimes from live music too. But I know a lot of times our police officers, certainly the East Precinct, sometimes will at least follow up with the business the next day per se, and usually the businesses try to get into compliance. But like I said, I do feel like that is a larger issue than just from STRs. I mean, I'm not discounting it from STRs, but I don't feel that complaint is isolated to STRs.
Yeah, and that may give us, I think, all the more reason to ask for that. So that's a really good point. Great. Anything else on things y'all have heard from the community that aren't already on our agenda?
I just want to add this to it. We understand that things happen in increments, so I think that it behooves us to look at the increments we choose to pursue, so that we end up where we need to be, because I feel like throughout the arc of this conversation, we've all agreed that the essential missing component is effective enforcement. And I understand that there is this, the cops are only going to do so much, and you don't want to put somebody from codes at risk that's not trained for it. Just as long as we are moving toward a resolution where it's not an ongoing problem. That really is the biggest issue that we hear as realtors about, oh, I don't want to live next door to one, or I want to buy one, what's the problem? We're kind of on both sides of that scale, So I just think being thoughtful about the increments that we choose. And I think that Brett makes a great point about, it's not just the short-term rentals. If there's short-term rentals are kind of clustered around party central stuff, and there are these issues on Music Row So it's just, and it's not just specific to Brett's councilmanic district.
Yeah, that's a great point. Other businesses as well. Okay. Duly noted. That's great. So just update on the state activity is the next item on the agenda. Just to, I think everyone got the word. There was some proposed legislation at the state level that would have further reduced our ability both to regulate and to enforce. And ultimately, all of those ended up being voted down in committee, so they never made it to the floor, which is good. And I believe that now this is making its way into enough small towns that I think rural legislators understand the benefit of having workable rules that are, unique to your city there. So hopefully this will become less of an issue in the future. But again, I think we do need to be mindful that there are different viewpoints, and that as we move forward, I think the beauty of this group has been having all the different viewpoints represented, so that hopefully we can make rational, calm decisions that will be viewed at all levels as beneficial. So that's our goal. So proposed draft revisions on items discussed already. The biggest one I want to maybe just tie a bow on tonight is the proposed legislation that Mr. Hargis presented fairly early on. And I think this may, depending on other items that we discussed tonight, may be the sum total of any legislation that needs to happen. My hope is that at the end of this evening, we can make a statement about that. So I will ask y'all to keep that goal in mind as we continue. So this says ordinance BL 2022 something or other, that's to be, and it does, I think, three things. Joey, if you want to tell us kind of what the basics are and remind us how that works, that would be great.
Sure. Well, the really three, I was just sitting here making some notes on item number 2, but the first one is revamping our requirements for new applications that come in as far as documentation, which need to be provided. The current language discusses 2 forms and it provides a list of any of these 2 items. The thought behind this, that some documents clearly have more weight when it comes to the owner-occupied than others. An insurance statement or a bank statement are much easier to change your address on, and they'll do it almost, without asking, versus a Tennessee driver's license or other government-issued identification, voter registration cards, something from your employer on their letterhead saying, stating this is the location of it, and sort of creates a 2-tiered system, one that carries a little more weight, which we identified as Group A, and then items in Group B are lesser weight, but up the number of documents needed from each of those, from just 2 overall to 2 from Group A and 3 from Group B. And Group B includes things like check stubs and work ID badges and insurance policies and W-2s, bank statements, those types of things. Revamping that, also, we're going to amend the renewal section to include those items annually. So that we're going to check those going forward. Current system right now is just signing an affidavit saying, yeah, everything I turned in last year or 2 years ago is still the same. We're going to ask for that documentation up front on the renewal side. And since we do allow renewal submittals to be done online through Codes' e-permit system, they'll upload those documents as part of that.
Can that be done securely?
Yes,
Okay.
my understanding, ITS, yes. I'm not an IT guy, so I'll defer to them. But yes, to allow folks to upload those.
Okay.
We still accept by mail, in person. I think we do occasionally get some folks to come in person to do that.
Great.
The section 2, the notes I was making, I was reading through the current ordinance, so I was like, it may, actually, I'd called out creating a different section of the code. I may just amend the section that's currently in there that talks about revocation of permits. The section currently says denial or revocation of permits, and this denial section is what I originally wrote this for, so I'll incorporate that language under the existing denial section. I'll get Metro Legal to help me sort of phrase that.
And the key thing here is if it's clear to you from either something the owner has said or indicated or Metro documents indicate that what they're telling you about where they live is in conflict with what you're seeing somewhere else, that we're officially giving you the discretion to deny
Yes.
the owner occupied
Yeah, and
permit.
instances of that, when I include owners' written statements, we've had a couple issues. One, social media posts that talk about, my home in Los Angeles, I live here, yet they own an owner-occupied permit in Nashville. Those two things can't both be true. Or we recently had an applicant who obtained a permit and obtained a building permit request on their short-term rental unit, but stated in their own documents that they live next door. They didn't live on the same property. So those types of publicly statements are grounds. It's implied I have that power already as part of zoning administrator review. I think it's helpful to us and future zoning administrators to be able to point out, here's a section of code that gives us authority to do such. But it's the general type stuff we look at now, as far as their increasing the documents that we require and on renewals, checking that out too, I think will help cut out, at least the goal anyway, is to cut out fraudulently obtained permits. And those, when we do discover fraudulent permits, we do revoke those permits from having. So I'll revamp in the current section under the denial and revocation section, and we'll include that documentation there.
So are you saying that you'll need to add language about being able to deny renewals on the same basis?
Yes. Yeah, in the renewal section, because the current section talks about revocation, but it talks about revocation of existing permits. It doesn't discuss denial of applications in that section at all. If you look in the current code, under letter L, it talks about, upon filing of complaints regarding STRP permit in section 1. Section 2 talks about if the zoning administrator determines, and this matches the state law about 3 violations of generally applicable law. It talks about the revocation of permit, but nowhere in there does it talk about the denial of an application. So I just include language that I'm proposing here and put it in that section. Maybe shoehorn it between items 2 and 3 there. Item 3 talks about before revoking the permit, we have to give the permit holder 15 days written notice. This one, we would provide written notice of the denial of the application and their ability to appeal to the short-term rental board, should they think I've denied it in error.
And then Mr. McBroom had suggested the no new permit shall be issued to someone who's already in a violation that hasn't fixed the violation.
Yeah, we do
And
have
so
some
we can-
language in the building code in chapter 16.4.172 that talks about, and that language says, in addition to any fine imposed or violation of this title, permits granted under the provisions of this title may be revoked by the director, and that director here is the Director of Codes Administration. It says, no new permit shall be issued to a person guilty of violating any of this title until the work done in violation has been corrected to the satisfaction of the director. The goal here was we had a contractor who's they haven't finished the job, or they haven't performed like they should have on this job. Until they correct this job, we're not issuing any new permits to that contractor, and that's the genesis of that section. But maybe including some language like that, we're not issuing due to a violator, but Mac can certainly talk about.
Yeah, really my thrust in bringing that forward was that we have many short-term rental operators that have multiple units. And so if we have violations at one unit and they're applying for a permit at another, then we would not issue that permit if this language is included in the ordinance, which it will send a message, and in addition, it will encourage compliance.
I think that's good. Thoughts on that?
No, I think that's good, and I think something we've talked about earlier is that, you can, the best predictor of future behavior is past behavior, right? And if somebody's not complying on one property, it's not hopeful that they'll be complying on the next one.
Yeah.
And it would be a good carrot to hold out in front of them too. Until you fix this stuff, you're not getting another one.
Right. And maybe if you do, you will. So puts up some positive reinforcement.
So the section 2 of the draft legislation, that'll get folded into existing language under revocation of permits and denials. That section already exists, so we'll beef that section up with that language.
Okay.
Third section of this talks about where there's been a change of ownership.
Sorry, I have a question. Are you at section 2 on page 1?
Yes.
Is it already that they can't be an LLC if they're going to be an owner-occupied? It's already,
For permits now issued, there's a period of time which owner LLCs were permitted, so we have to look at those under that,
right?
under the laws that existed for
But
them.
currently, that's
But
how it
currently,
is.
they are
Okay.
not allowed.
Okay.
It would have to be a
Natural
a natural
person.
person. And that's the current law, state of the law now. It has been for probably some few iterations of.
Yeah, that was an early clarification.
Section 3 talks about change of ownership. That's one that currently I'm a little bit in limbo with the state's action last session of determining what is a transfer under state law. If you guys seen that section, it talks about these things are not transfer. They worded it backwards. It was almost a negative. Like these three things are essentially transfers and nothing else is. So we've had a recent rash of cases we've had to dismiss because although it is a quitclaim deed that was not subject to a transfer tax, and it didn't meet any of the three spelled out items under the state law, so it wasn't a transfer, so I couldn't revoke it. Whereas in times past, I had revoked those permits. We had one agenda, I think, of our short-term rental board, went from 10 cases down to 1, because 9 of them were those what we had always considered transfers, quitclaim deeds, changing from one to another, did not meet the state's language. And Metro Legal's like, hey, we need to follow the state's language here. So the net result was not what we looked for, but the end result is exactly what the legislature did. There's talk of the legislature to correct that. I think it matters for real estate transactions and that sort, but the effect was kind of broader than they imagined, I think, when they passed it. So section 3 of this, I'm going to follow our lawyer's advice and continue to enforce what the state does as far as what is a change of ownership, what is a transfer.
And does that, I know we talked about some interesting situations where there's a divorce and the wife changes her name, but she's still the owner. Does this put us in any?
Yes.
Does this give us the ability to?
We're still sort of tied to the state's actions even on those issues.
Okay.
The state used language like revocable trust, and there's no such animal in real life. All trusts they're revocable up until death. You know, if it's that sort of thing, they become irrevocable trust. And the language the state used, because I'd called a local attorney, like, are there different kinds of trusts I'm just not aware of? And she said, no, all these are this category. So, yeah, even those divorces we're having to.
Okay,
to piece
so
through and-
our hands are a little bit tied on
They
that
are
one.
tied.
Okay, because I know there was some case where someone, I think, went to the state over us because they felt like what we had done was not rational, and it may be because we didn't have the ability to do that, or if there's anything we need to fix.
Is the provision about the property being held by a natural person versus a trust, an LLC, or like that, is that state law?
That is local law only for the owner occupied, because to be an owner occupant, you have to be a person.
And that took effect January the 2nd of 2018 with Bill 608. Prior to that, an LLC or any type of general partnership, any type of company could obtain an owner.
No, I believe it was earlier. It was before 608. The original bill has disappeared, so I don't know that anything that happened before then shows up anywhere, but Councilmember Mendez did it as an amendment to the original bill.
I thought there was pushback on that, but I could be mistaken. I thought that they were saying that's not a legal thing to not allow people to buy a property in an LLC. So that's what a lot of people do when they buy their personal property.
Yeah. I mean, I think that may be true, but this is a permit, and we can set
Yeah.
conditions for a permit.
Okay.
So I know it exists in 608. I think it existed before then, and I don't know that that's critical to the decision but so what I'm hearing you saying is in terms of refining any language here, our hands at this point are sort of tied by the state definition, and maybe there's an opportunity for the state to refine their language.
They are.
Okay.
They are. And so, we'll have to revisit sort of Section 3 and ownership changes once the state deals with it next
Okay.
session. Let's see how that goes. Section 4 talked about amending language, and Section 4 and Section 6 are the same. One deals with owner-occupied, the other deals with non-owner-occupied. In Title 17, which is where the short-term rental law used to reside, which was part of the zoning code, the zoning administrator has the authority to curtail services if there's violations of the code. The language in that talks about, and it's what I've copied here verbatim, I can go to court, I can seek an injunction, we can also curtail services. It's generally water. We don't turn off people's electricity, but we do have the ability to cut off water services. So you can think that the adverse impact on short-term rental use, if there's no showers and the toilets don't work and the kitchen sink's not flowing, that I have that power in Chapter 17. When the short-term rental code moved to Chapter 6, that language didn't follow. So these two provisions would grant that same authority that was there. And we would use these in instances where we have convictions of violation. We can't serve these folks. They ignore court orders. This is not going to be a remedy that's used every single time there's a violation. These need to be the worst of the worst that we've already been through the legal process, and we've gotten a judgment and an order from a judge to stop, and they're continuing to operate. Those are the instances which I see those would be done, but at least it's another tool in our toolbox. The legal department feels I need this language in Chapter 6 for it to have that authority, and the water department wants that authority specified, that they're willing to do it, but they want to see it, in the code
Gotcha.
that language is there. So Sections 4 and 6 are the same. One deals with owner-occupied, the other deals with non-owner-occupied. Then backing up Section 5, again, it's the ownership language. So we're kind of hamstrung. Sections 3 and 5 may ultimately pull out of this ordinance, sort of
Gotcha.
pending the state's action. And that's changed from the time we first wrote this,
Yeah.
4 months ago.
Yeah,
So,
I thought that one had not passed, but, well, if our hope is perhaps to do this soon, maybe you can, communicate back with the group on where 3 and 5 end up once you talk to the lawyers.
yes, sir.
Gotcha. So at this point, I think these are things that we agreed to early on that the owner occupancy, piece has been a huge, issue. I think just the verification of that, or at least ensuring that it really is what it's supposed to be. So this deals with, I think, very effectively, as well as giving them some tools to deal with the worst of the worst offenders.
Yes, and the reason that I really was interested in this was because of the deadline that took place January 1st of this year, where now non-owner occupied permits are no longer issued in any residential zone districts, which is a great benefit to the residential zones, but you still will have people that will purchase properties in those zone districts not intending to be owner occupied, and yet they still want to obtain permits. And the temptation is just so great because it seems to be relatively easy to produce the necessary documentation at this point. So the whole thrust is we have limited enforcement for short-term rental properties, and once a permit is issued, the time spent building the case to have the permit revoked or to bring a court case is quite lengthy. But if it can be eliminated during the permitting process, it saves us a great deal of time as far as enforcement is concerned, and that allows us to shift those efforts in that time to more enforcement of a wider array of the ordinance violations.
Good point.
So this might sound like a little bit of a hair-splitting question, but as I read this, it says 2 documents from Group A and 3 from Group B. Could you have 4 from Group A and 1 from Group B?
For those, you could, you could bring 4 from A. It would still require, if as listed, it would still require 3 from B, as well. It's not intended to be a 5 overall, because that's kind of the situation we have now, is they pick the 2 easiest things to show, and give us those. The intent is, these carry much more weight. We want to see those and include some from both. Then Matt can talk to
Yeah,
you.
well, you're free and encouraged to exceed the
Oh, please.
requirements, but you will have to meet the
Yeah,
requirements.
at least the minimum is listed there, so. Sure, give us as much documentation as you like. That helps your case, helps your, well, I say that from the operator standpoint, it helps their case from those times where neighbors say, well, they don't live here, we don't believe they live here. And as I've told Mac staff, before we revoke, I need more than just hearsay. I want to see, it's not even a group of people all saying it. I need some more evidence, because they've turned in this. And you're saying I should overturn their application based on a driver's license and a voter registration card. I better have a lot more. So the idea, it does protect the operator too. Sometimes in this, it may get that we're against the operator, but I'm looking at it from the standpoint of trying to protect the operator too from false claims or us revoking a permit we shouldn't have because they were fined. Maybe they haven't moved in yet, whatever the reason is.
Well, I mean, to John's point, if we say 5 documents are required, at least 2 from Group A and the remainder from Group 3, would that give them
Sure,
more
yeah.
flexibility?
That would be totally fine.
I mean, that sounds like good math language. Does that work legally? John, does that address what you were thinking about?
Yes, it does. Thank you.
Because Group A is important stuff and hard to forge. And then the final one that we had talked about, possibly including something in legislation, I'm not sure we ever found a satisfactory solution, was the parking issue. What's currently written is that the house has to provide the same parking that it does as an owner-occupied home, or, I mean, whatever the zoning code says has to be supplied in terms of parking for that size residence is what's required. And I think in many cases that works. There are not infrequent weekends where it doesn't work and where people are parking on people's yards. So I am open to great thoughts on what, if any, solutions we can offer, because I don't want the folks who have come to us looking for a solution to feel like we haven't even thought about that one. But I don't feel like we've gotten anything either on the website or into legislation that improves on where we are on that. So any further thoughts on that?
Well, at the last meeting, the information that I was asked to compile was,
I sent that data out also.
it was by complaints by council district, which IT and I were not able to break it down on that basis. However, we were able to break it down by zip code. And I compiled a list that shows what areas of town are encompassed by each of the zip codes and the number of complaints that were reported under each of those zip codes. Now, applying this to certain zip codes or council districts, I think would probably be almost impossible. But one suggestion that was made at the last meeting, and I'll just throw this out there because I thought it was valid, but again, it might be difficult to enforce or to craft in the wording of an ordinance, but it was that exemptions are available, and the closer to downtown you are, the greater the opportunity for exemptions, being close to a bus stop, being close to bike bike lanes on the streets, various things that allow you to cut down on the number of parking spaces that you're actually required to do. And the removal of those exemptions, but it would seem to me that you might run into trouble with doing that exclusively for short-term rentals. Others might want it to be applied to everyone. I don't know the specifics of that. I just thought that it was a valid suggestion, and I wanted to throw it back out there for discussion.
Gotcha. So just for context, in the parking tables, it says, for a single-family home with 1 bedroom, 1 house, 2 bedrooms, 1.5 parking spaces or whatever. And then it goes to, for these zoning districts, these exemptions are available. So
I just have a really quick question. The data, was it over what period of time?
It was from the beginning of the host hotline through the last meeting.
So
March.
from the very beginning of us kind of having that in place, so 2-3 years?
No, about 4.5 years.
So this is the total number of complaints? Not that much. 117 total.
that, that's
Well,
noteworthy.
Yeah, well,
Surprising.
and,
That didn't include the 100 that I got by email.
right. Well, and, several of us council members including council members who often field concerns about short-term rentals are considering legislation to eliminate parking requirements entirely in their urban zoning overlay. So, but, it's one of those
Maybe
things that we
point.
balance because, we do hear about it, and when situations are bad, they are noteworthy about how bad they are, but we're also trying to balance the strain, particularly on multifamily housing, that our current parking requirements propose, and that is a bigger issue, I feel, than the occasional instance of having someone have lots of cars parked nearby. Even from a from a property standards codes enforcement standpoint, there are houses where the household has a large number of cars, right? And so then we run into issues of their parking in the grass, and then codes is being called on that, and those are from folks who definitely are residents of those houses. So it's just one of those things that, I understand the concern, but it's the difficulty of parsing that out specifically to short-term rentals. It's just so difficult, and the social and economic impacts of requiring parking as it relates to housing is just such a much bigger issue that I think I still feel like on balance, it's better to remove the requirement for parking than to try to enforce it. I also don't know to what extent it's possible or has been possible to tie any of the cars that are parked on a street to a short-term rental, because if they're parked on a street and if they have a license plate and a tag, they are legally parked.
Right.
And that's just the case. So it'd be very difficult to enforce that, I think.
And I know part of the work that was done earlier in these meetings was to make the hotline maybe more visible on the website, and maybe, revisiting it in a year if we see there's a bunch more complaints now that people can more readily find that number. That would be interesting. Because Germantown, who I think was having the biggest issue or vocalizing the issue, only had 9, whereas East Nashville had 23, so
That's a valid point.
So,
Yeah.
just being sure that I grasp this. So if we use the parking table and the house has a final UNO, there's not an additional parking requirement added as a condition of the permit.
That is correct. That is
And-
what is currently on the books.
And as I've been reading about the removal of parking requirements to increase density and development and all of that stuff. So it does, am I correct in assuming here that the parking issue is kind of receding?
I don't know that the parking issues are receding.
Well, just as a matter of concern, as it affects a condition of a short-term rental
Yeah.
permit. The parking issues are not receding.
They're
but-
not receding.
But I do appreciate what y'all are doing about addressing the parking, because you're right, there's so many other cities that have encouraged development because the cost of providing parking can be onerous.
Yeah. So I think that is a larger issue that we probably need to look at more comprehensively.
Well, another thing too that was brought up at the last meeting, and it's a very valid point, a lot of the areas where the parking complaints originate, just because there happens to be a short-term rental property in the area does not mean on weekends that all of those cars are associated with that property. I mean,
Could be the restaurant. That's very true. All right, so we're going to leave that one as larger than can be handled here. So I think that's it for the items that seem to connect with legislation. I'll jump down to what had been pending legislation. They've all been withdrawn. Although the parking, the distance requirement from churches and schools and parks, we've seen a few of those now in council. Most of them have passed. One of them was sort of an opportunity for the neighbors to say there are 3 others in this multifamily house and they're all problems and we don't want another one. And maybe that's an appropriate opportunity to have. So that, I don't know that we've got a large enough data sample to say that seems to be working out okay, but we're beginning to learn how it's working out. Councilman Withers, you want to add to that?
Yeah, I mean, we've had a few of these come forward. I think for council, I know I had one that was off of Main Street where it was destroyed by a tornado, and for me, like, I'm not going to use this to be punitive, right? But I think we've also had some where you might have a townhouse development, let's say, and a portion of the townhouse development is closer to the church than the other portion, and so sometimes the council member in those cases has sought to treat the entire development equally, right? And to say like, well, if the one next door can have it, I'm not going to deny it for this one for the one next door. But I think overall the council is probably still a little bit skeptical about allowing this for new permits that are coming through, if they're not, like I said, kind of rebuilding something that was there previously or connected as part of a little bit of a larger townhouse development. But we just haven't had enough really to see what that pattern looks like yet.
There doesn't seem to be a reason to mess with it at this point, I guess I would say.
My
Devin,
question,
then-
I asked this before, and I just want to make sure I understand because I'm not sure that I fully understand. Is it, when the bill was passed with the amendment that as long as the master deed had been procured before September 2020, or I think that was the date, then this was not applicable and it was just new properties? But I feel like when it got transferred over to the new chapter, that amendment didn't get transferred over, but I could be wrong. That may be what's happening. But I remember when it was voted on in council, it was approved with the amendment that anything that with the master deed before September 2020 was not considered.
There was never an official council process to move it. I think that was done
Right,
administratively.
exactly. Right, and when it was done administratively, I think the amendment did not get
Did not
moved.
travel with it.
And
that
it is a huge deal, obviously, for someone purchasing a property that was built in 2017 and should be able to get one, but they happen to be 90 feet away from a school, and then all of a sudden you can't get a permit.
because that didn't translate.
Right.
Can one of the lawyers in the room comment on that? I'm looking at the only lawyer I know.
I don't know that I fully know which section that is. Mac, if you've got that with you. We can give an on-the-fly opinion.
But it seems like if that was part of the bill that passed and we administratively reinserted the bill into section 6, we should reinsert the amendment as well.
I just remember it was very heated, and that amendment got it to be kind of accepted by the community.
Uh-huh. We're looking. Thank you for asking that question. I think part of the answer may be they'll look into it, but I don't think it will need to be legislation, but it will be an administrative fix once we determine if that needs to be fixed or not. And while they're looking, any comments on the website? The only feedback I've gotten on the website is still some concern from one of our task members, I think does a lot of management, who has been very disciplined about saying that the current law says you can't advertise the whole house for permits issued after such and such a date. And just concerned that is not as explicit as it might be on the website, or,
Well, on the homepage for short-term rental on Nashville.gov, the second bullet item on that page is for new short-term rental property permits and permits issued after 11/18/20, refer to substitute orders, and that's actually a link. You click on that, and it takes you to the substitute ordinance, which states, along with the exception, and I'll read from the ordinance. Further, other than for legally permitted detached accessory dwelling unit, for a legally permitted accessory apartment, or for a two-family residential unit under common ownership with a two-family unit on the same lot permitted in accordance with subsection E1F of this section, advertisements for an owner-occupied STRP shall not advertise availability of the entire/whole home for STRP use. And so that's the second bullet item with the direct link to the ordinance. I don't know if we could put it any more prominently.
So when you look at it, it says. Do you think maybe we could add to that for new short-term rental permits issued after such and such for advertising requirements about whole house rental? I mean, do you think we could put those words on that page as opposed to having to dig into the, into the ordinance?
I suppose we could, but our discussion surrounding that was that we would prefer for them to click on the link and read directly from the ordinance themselves, due to the fact that there are exceptions.
Mm-hmm. Well, I mean, I think if we just said about whole house rental, and then they would say, I wonder what it says about whole house rental. Maybe that would, and I mean, then at least you would know that there's something about renting the whole house as opposed to not, without giving any indication that you can or can't advertise it.
And
What do you think of that?
And then also, we revised the owner-occupied STRP affidavit, which has to be notarized as a part of the application process. It reads, I certify that I will not advertise the whole/entire house on the website, on a website platform.
Gotcha.
So-
Okay, that's
So
pretty.
for the person making application after that date of 11/18/2020, it's spelled out, and it's
Gotcha.
it's a notarized affidavit.
This is a little bit of a tangent from that, but it's a question that I got asked in the past week by a client. So, as I understand it, the permitting process is you are grandfathered in terms of your eligibility to hold a permit, even if the ordinances change. So if you bought a not owner-occupied unit in a zoning code that starts with an R, as an example, you can still renew your permit. If you sell it, the permit does not convey and the next person is not able to, right?
That's correct.
So, but, and this is the point of clarification this client was looking for was, but it's still, whatever you're operating is still governed by the existing ordinances. There's not like, oh, you're only governed by what existed in 2016, even though it's 2022. You're governed by the current ordinances. It's just, no?
These poor guys have to keep up with every set of ordinances as they change, which is one of the reasons we're here, is to try to only have one change in ordinance per year as opposed to 5 in a year. Because by state law, you were subject to whatever was in place when you got your ordinance, as long as you maintain your permit. That's a lot to ask of these guys. So, so that's why we're at least trying to combine changes into one single ordinance.
And this is a bigger question for this is, so how do we change that? So that
Go to the state.
Yeah, that's.
the state legislature tells us that's the way it has to work. So if I got a permit in 2016, everything I have to do with the operation of my unit is governed by whatever the current ordinances were in 2016.
Yes, as long as you maintain your permit.
Which for me, in the legislative portion of this, that's why I wanted to focus on business process of how we do applications. I did not want to get into legislating the operation of the business. I just, if you look at my proposed ordinance changes, they're all administered paperwork. Like, what do you need to submit? I'm sure there's.
So we think these things will apply to everyone, just in terms of renewing their permit information. But in terms of noise or HPRs or things like that we've tweaked, and it's a moving target.
Well,
Your
could I-
question about the HPRs, I had made a determination back in February that section, because when you read the language, otherwise qualifying properties with a valid master permit on file with the Codes Department on or before September 1st, 2020, or who have completed at least 50% of construction of a new unit as of September 1 would not be subject to the spacing provisions. So I made a determination that the council's intent in this is for projects underway or just recently. I've got my master permit, but I haven't necessarily started building the individual units, not for fully completed developments back in 2016. This was intended to cover those that were in the pipeline at the time they were being constructed.
That's definitely not how the community was hearing that, for sure, because that immediately affects anyone getting a new permit. I mean, downtown, you can't throw a stone without hitting a church. I mean, that's why that was such a big deal. So I definitely, and the only reason why I'm bringing it up is because I have heard of a lot of people now being affected by this rule who we did not think that's how it was being interpreted. And I mean, it's causing some major issues. So, I mean, I don't know how it got transferred over, and it didn't get transferred over in the way in which the community had finally negotiated it to be written.
That, let's make a note of that to continue to follow up on that amendment.
And part of that was the 100-foot rule too, wasn't it?
Yes, that's what we're talking about.
Yeah. And then there's, at what point do you measure from to determine the 100 feet?
That's in there. They voted to measure from the property line, not from the building. That was part of it. It was a very contentious bill.
Well, the other part too was you didn't want to go through this every time the unit sold. Like, once the use was established, it was established. So, if you weren't subject to it, you wouldn't be subject to it going forward. I'm certainly happy to take another look at kind of all of that went on.
I'm just over here like having a slight panic attack about every single short-term rental unit that anyone I know is buying right now, because that was already an established short-term rental, but then they have to get a new permit because they're a new owner. And so I didn't think I was going to have to worry about this as long as it was built before 2020.
Yeah, you don't have that issue. These would be, no, the change of ownership triggering a new permit, you would still be exempt from the 100-foot spacing because the use was established in that. These would be brand new, never had a permit.
Right.
From the get-go. Let's say the development was built in 18, no one
Right.
ever obtained a short-term rental permit.
Right, but even if they didn't have a short-term rental permit, but then it's zoned to allow it, and so they want to get a short-term rental permit.
They would be subject to the 100-foot spacing requirement under this because there was no use established for short-term rental on that property.
But I thought that use wasn't established anyway. It's a permitted use, and that's why it doesn't transfer. Just like it's not it's residential use, but the permit is not something that's
Well,
runs with the property.
The use was established by the prior permit. In the instance where there's not a prior permit, the use is not established.
You'd think if the use is established, though, then a permit would transfer with the sale of a property.
Well,
mean,
I'd say
that's-
that, but the last sentence of it says, provided that any qualifying unit for which a prior non-owner occupied STRP permit lapsed will be subject to the provision. See, and so it's talking about, you know, I had a valid permit, but I let it lapse for some reason. That's not the situation you're describing.
Right.
These are, they're valid permits, they never lapsed. But in ones that do lapse, they are subject to these provisions.
And the lapse condition is 30 consecutive months of not operating as a short-term rental property with an expired permit. So that's quite a large window, something we rarely see.
And that comes from state law. That's the state law reaching in and saying, okay, this thing has to be abandoned for more than 30 consecutive months
Right.
for it to be gone.
So if someone had a short-term rental permit, and then, let's say, a new owner didn't, and they owned it for a couple years, and then another owner comes out and purchases the property, are they now required to follow this 100-foot rule?
If it was 26 months.
No. But if
No.
it were 30 months, yeah, they would be subject to it.
Yes.
But it just simply and now we're talking non-owner occupieds here.
Yeah.
right? Okay. So for those, just a simple transfer, well.
You can't
yeah,
transfer.
We got to
I
talk
know
about
what you mean.
transfer. Is
Yeah,
it a
yeah.
transfer? See, it may
Yeah.
not be a transfer. It could be a real estate sale in your world. But in our world, for the purposes of ownership, it's really not a transfer because it's not subject to a transfer tax. So the permit never died.
Well, no, I mean, I'm just talking like, this is a new owner getting a new permit. But let's say, I'm saying in this situation is it's a building that was not previously used for short-term rentals, but it is zoned to allow short-term rentals.
They are subject to the spacing requirement
Okay.
under this code.
That's definitely not how it was interpreted at the time of the bill. And so that's, I'm just bringing it up because
No,
I
no,
just think
that's
it will be something that gets brought up.
So if there was a building built before September 1st, 2020, but it had not been used as a short-term rental property, the use had not been established, it's subject to the spacing rule.
Yeah, that's my belief. It's subject to the space rule that when I read this, and again, I wasn't involved during that time, so I don't have the benefit of being at the time.
And anything built after September 1st, 2020
Is subject.
is subject to it.
And I don't have it before me, but Joe, I believe that says it's intended for new construction, correct?
But this one, it says, properties with a valid master permit on file with the Codes Administration on or before September 1, 2020, or have completed at least 50% of construction on the unit as of September 1, 2020.
But then
But-
Would
the,
not be subject to
It
the
doesn't
provisions
mention
of this
anything
code.
about
then-
previous use,
But
right?
then the,
Doesn't mention
Yeah.
like previously constructed
Right.
units.
And so that was taken, and I think that is the part that did not get transferred over to when it got moved to a different chapter. And so that's the concern I've heard people bring up.
The chapter change wouldn't have changed that, because that's the
Okay.
language of the amendment
Okay.
to the bill. I mean, it says
So
those
the
two
amendment still
things.
survives.
Yes.
in that amendment, I believe is where it says that it's intended for new construction.
In the preamble.
What's that bill number?
2019-78.
All right, I got that.
Let's see, I'm looking through all the whereas provisions at the beginning. And I don't think it says, the purpose of this distance requirement is to address the negative secondary effects associated with the sale and consumption of beer near churches and schools, daycares and parks. Metro Council has heard concerns from the public from numerous locations. See the January 3rd, 2017 public hearing regarding ordinance 492 and the May 2nd, 2017 public hearing regarding 608. about the negative secondary effects associated with the operation of non-owner occupied short-term rental properties in Nashville, including public intoxication, lewdness, and excessive noise. And whereas it's in the best interest of the residents of Metro government that a minimum distance requirement be imposed for new non-owner occupied short-term rental properties. But it doesn't say as far as under construction.
Can we,
I think, well, as far as sort of wrapping up that portion, I'm happy to take a look at sort of the hearings that occurred during that bill and see, because I wasn't even at the codes department, man. I wasn't here, I was in private practice. At least from the standpoint of, my interpretation was to protect those things in the pipeline, which is what we ran into with the other short-term rental bill.
I thought it
But
was pipeline and like existing properties. Because that greatly affected their value to not be able to be resold as a short-term rental if that rule then affected them. That was when I just remember that being the major issue. It was greatly affecting their property values.
No, I'll be
Yeah.
happy to take a review of that.
Awesome. Thank you.
And see, and happy to respond back to them.
okay, we'll review further. Okay, thank you for raising that question. Okay, so that's an interpretation thing. So, let's see, and then we withdrew the one to remove residential for the definition. I don't see that one coming back. This proposed STRP overlay, I mean, I think we ultimately decided that didn't bring any value it was less onerous to y'all to simply rezone a piece of property than to, and that's the same legislative process in terms of community engagement and council member support as getting an overlay. And that made your life much easier than.
But there is an instance in which,
I think you said for commercial areas or HPR, maybe it made sense there.
Is this the overlay that was proposed by Councilmember
O'Connell.
for areas that had an NS designation to
Right.
add an overlay that allows the owner occupied back?
Right. And the discussion here was, as irritating as spot zoning is, that would serve their function much more clearly than having an NS zoning with an overlay over it. And so their request was to treat it that
the
way.
exception, that would work beautifully in residential zones, just to remove it. But in zones where not owner occupied would be allowed without the NS designation, then the overlay, I believe, would be necessary in order for it just to be limited to owner occupied, if that makes sense.
If we wanted to limit it to only owner occupied.
Well, I believe that was what was in the.
Because right now it's sort of all or nothing, right? I mean, because I think we're talking about Germantown, which is mixed use zoning.
Right.
So it's not a residential zoning. So ordinarily the non-owner occupied use would be permitted. And
So then an
And then you go
overlay
to
would.
NS, which doesn't allow any. And then the overlay adds back in the owner occupied possibility.
My point, Councilman, is you're going through the exact same process to apply an overlay. Just go through the process to revoke,
Just rezone.
To rezone it out of NS. I mean, if the intent is allow these properties, whatever they are.
Yeah, I think that what the council member from that area was trying to find a way to do is to, like I said, right now, it's sort of within mixed-use zoning, it's all or nothing, right? And so he was trying to find a compromise to allow the owner-occupied only, but I know that that's
So that would be an MU with an overlay that allows
owner-occupied.
owner-occupied only. So it's really an overlay NS.
It's an overlay that adds back in owner-occupied only, yeah.
Or takes out the non-owner occupied, which is there in MU right now, isn't it?
Right.
Right.
This is,
Okay.
this is the email that I wrote to you concerning this on March 17th. Based on my reading of the proposed BL 2020-504, the NS variant zones districts in which the underlying or base zone allows not owner-occupied STRPs, the owner-occupied short-term rental overlay would be necessary. I would like to request that Councilmember O'Connell revise Section 5, Point B, eligible zoning districts. Owner-occupied short-term rental overlay districts shall only be applicable to NS variant zoning districts, and then adding these words, in which the removal of the NS variant allows not owner-occupied permits.
Gotcha.
That, everything was there already except for that last portion.
Right,
So it'd be the OR and then mixed use,
right.
pretty much, but it's still a very complicated process. And
Yes.
I don't believe that has even come before the planning commission.
No, it was withdrawn.
Yeah.
In good faith that this group might find other solutions. So right now, it's kind of sitting. I mean, my goal is for us to, I think, know where we are tonight, go back and talk to our communities and have them say, this is good, this will last us for the next year, if we can get enforcement working. I feel like we're making really good strides on the owner-occupied piece of it, and tiny strides on the enforcement piece of it. If we don't address this, is it going to come back in 2 months?
I mean, for the NS, I mean, I think the point is valid that when that was discussed by council to create the NS districts, that the thought was, for instance, I have a property that I rezoned on Woodland Street. The property owner said, I really want this to be housing. We're going to go ahead and take short-term rental off of the plate, just so everyone knows that we want it to be apartments. That's what the neighborhood needs. And right now, and what had been the only way to do that was through SPs. And so that was the idea behind the NS, as it was discussed by council, was to say that is for specific times, usually associated with a request to upzone a property, is to say we will give you additional uses or density if you remove the short-term rental as part of the trade-off for that. The concern that was expressed at public hearing was that those would be used in a blanket fashion, and that is sort of what happened in at least a couple of areas, right? And so I think that is the concern, and certainly district council members have a lot of zoning authority, as we know. But that is kind of where that came from. I mean, I would almost have said that the better approach would have been, instead of creating a district, basically would have been saying, if you're creating a zoning district exclusively around short-term rentals, just to have one that is owner-occupied only in the first place. That would have been perhaps an easier way of doing that, but that's not what happened. But I think that, like I said, the concern about district overlays that Councilmember Allen, as you know, even with conservation overlays, you try to get as much agreement as you can among property owners. You don't always get 100%, but you try to get as much as you can. Districts do have to be contiguous, and so you're either going to have districts that are really, really tiny, or you're going to have a broad area where most people are happy and some are unhappy.
Right.
But for the short-term rental aspect, the discussion that we had at council was that the NS, as I recall it, was meant to be as a trade-off for a potential upzoning and not as a blanket downzoning.
So yes, that, as you know, that was part of it. And the other, just to put this on the table too, the other variable is getting your council member to respond and actually bring it to council when you want to do the spot zoning. And from our standpoint as realtors, if there is an overlay, it's like one more layer to work through. It's a problem.
Right. I mean, so I think where we sit today is, if someone is buying a piece of property and they want to do it and they think their neighbors are going to be cool with it, then they need the support of the council member and the neighbors to show up in Metro Council and get the NS removed, and then they can get an owner-occupied permit. That's kind of where it sits today. And there are cases where people will show up and say, nobody cares. And if nobody shows up and says they care, then that's a place where it's not going to have the impact that we're trying to prevent. Hopefully they'll also be a good owner. So I guess so I think what I'm hearing is R and RS have a mechanism for individual properties to deal with, if you can get your council members' attention. What we don't have is something perhaps for MU, which has a concentration in a single part of town that has had a lot of concerns about this. And I don't think we have time to invent that tonight, but my question is, do you get the sense from that district that that's an imminent issue that we need to try to address in the next year? Or can we stew on that one? Or do we want to keep meeting, which is also possible? I do feel like if we're going to file anything, we are in a very tiny window before certain people reconvene and start looking at what we're doing. And I think what we've done is very reasonable and isn't going to raise any hackles. I just want to make sure that it also has addressed most of the concerns that people have brought to us, or at least that we've started in motion research on the other issues. So I think this is kind of the last thing remaining.
Yeah, I mean, Five Points has lots of MUL and stuff like that. I mean, there are other parts of town. It's just that, for me, it's not something I'm hearing a lot of specifically, at least today. But I don't think there's anything wrong with creating enabling legislation for that kind of an overlay. But I think from the standpoint of property owners who, you still have to get a council member that's willing, even just to have a community meeting
To make
about
it happen.
which that's different than saying, they're going to support it. And ultimately, sometimes it could be difficult to get a council member even to have a community meeting about it, I think. I mean, I'm just thinking, about how things can go wrong sometimes with that. Sometimes we do have council members that, for whatever reason, don't want to have community meetings, or sometimes don't want to have public hearings. We've experienced that in the council.
have.
So, that is the concern. I don't see a problem with creating another enabling piece of legislation. But then again, you end up in this stack where you've got sometimes, you might have a conservation or historic preservation overlay. You might have the urban zoning overlay. You might have XYZ overlay. Then you've got an NS designation. Then you've got an overlay that adds it back in. And so this wedding cake that you're stacking
Right.
up of all the overlays on this could all just be on one specific property, right? To have all of those pieces of that stack that's kind of difficult to work with. And the question is, is this a broad enough issue across the county that is needed? I'm not opposed to it. I'm just not hearing lots of outcry, even in 5 Points, where there is a lot of concern about it. I'm not hearing a lot of people sort of demanding that opportunity.
I would throw out this
Myself.
then. I would touch base with you, and I think District 19 are probably the two with the highest concentrations of mixed use. And what I would suggest is if it seems like this is something that is going to be needed in the next year, that we go back to revisit that bill with the idea of applying it only to the OR and MU as I'm not sure what it would be, it would be a downzoning essentially, or, it would be an overlay that would allow owner occupied but not non-owner occupied. Because right now, both are allowed. And if a neighborhood got organized enough to do that, then that would be a possibility that would exist. Is that a terrible thing to create the possibility for, and then it sits there and people use it or don't use it? Are you nodding yes, that would be terrible, or?
I just with the past experience of seeing what happens when especially if you get a council member who wants to downzone a bunch of properties, and then I've just seen it happen over and over where they say they're not going to use it that way, but that's how they use it. And it's just.
An overlay actually should be largish
right, it
areas,
should be large,
yeah.
But they do it regardless of if that's what the community
owners.
really wants. That's what I've seen. I think the trust of that being used correctly is low.
Mm-hmm. As Councilmember Withers has pointed out, even in the best scenario, and you can get 85% of people on board, that's still these 15% that, that are being dragged along with the will of the group. So, okay, I think then we just have some conversations with the council members and see if that's an issue that can wait while we ponder other solutions.
Yeah, and just brainstorming again, I'm like, if you were to create this overlay, since we're not going to create an NS, but with owner occupied for the whole zoning code, because even that was a lot. Bob Lehman is like, whew, I'm out of here over that.
That's what did it.
But,
Yeah.
but maybe a way of approaching that is to say, if you're going to do the NS, if you're going to do the overlay, it needs to be paired simultaneously to track with an NS. so that way you are eliminating non-owner occupied, but retaining owner occupied with, does that kind of make sense? I mean, I just feel like, to Deb's point, like, kind of what they see is like, oh, we're going to downzone all this stuff. And we might come back later and add it in for your property or not. And I think that feels like the property owners who are interested in that use are at a poor bargaining
Right.
position there, whereas if, like I said, the kind of the original intent of the NS was to say that in exchange, basically for an upzoning, we will, the trade-off is that we're going to remove this one use, right? And so if that is all tied together as one action, I mean, but, yeah. I just think it's
I'm
complicated.
getting permanent over here, yeah.
I have property owners right now with NS, and they're like less than a mile from Fifth and Broad. And so, and they have apartment suites in the basement, and they can't use it as an owner-occupied short-term rental. And so, and the council member, they've spoken to them, and they're not in support of changing it. So they're just like,
They're
at
stuck.
their mercy.
Yeah.
Yeah.
So let's not create more opportunities for that at this point. Okay, I think we've worked our way through our list. It is after 7, which was my goal. So two very large fundamental questions. Are we done? Or do we feel like, do we have groups that we can go back to and say, this is what we've done? Do y'all think we're done? And then we think we're done. And then, I mean, I'm comfortable once Mr. Hargis does some tweaking on this ordinance that we've looked at, filing this one at some time in the next month or two. I think sooner is better than letting it run into January. So that's one question is, do we feel like we're done with this piece of legislation that provides more documentation for owner occupied, gives them the authority for the very worst cases to turn their utilities off, and also gives you discretion on denying permits when you can have access to information that tells you it's not appropriate to provide those. Are we comfortable with this? Are we proud of it? I think we are. Okay, good. So you're gonna work on that and come back, and maybe in the next 3 weeks.
Yeah, I will. I'll work with planning staff on getting it drafted, and Matthew and the council staff.
Okay.
Getting it
Any other
proper
groups we should
wording.
be checking with?
They may actually be better sources for that information.
Any other groups y'all think we should be checking with? Yeah, probably good to get what we think is a close to final version before maybe y'all take it to your various groups and say, what do you think of this? But that'll be one piece of community engagement that we should have. And I think with regard to sort of a few loose hanging ends, which I think the parking and the overlay, I'm not sure that I can look the people that were unhappiest in the face and say, it's all better now. But at least communicate with them and say, if we can solve these other issues and make infractions less egregious and frequent, then maybe these other problems will go away. We can move forward with that. So my suggestion, I think, would be then, if you can get us an updated version, if we'll send that out to the whole group, even those who weren't able to be here tonight, and ask them to provide feedback from your various groups. Let's don't encourage total rewrites, but at least let them know that we value their input. And then communicate back via email, then, except for Councilmember, we'll use bang the table, and we can do it there. Okay. Then I think if we're comfortable with that, then we can, I think, through a group email, minus the other council member, so that we don't violate open meetings, decide if we feel like we're done once we see what that final legislation looks like. Does that seem like an appropriate plan?
And just the one other question about the distance.
Yes,
interpretation.
and I've got that written down. Joey will review further. It's in the minutes on that one. So the distance, the parking, and the I'm going to say the mixed use question are sort of a little bit out there, but I think there's something that maybe we chew on for another year and see how other improvements that we've made affect them, and you'll look at those 3 things. Is that it? Thank y'all so much for coming. I apologize for all the many reschedules, but it was important to have these 2 guys both here. So thank y'all for working around their schedules. We're glad you're well. And everybody else stay well. I got my booster today. So anything else before we adjourn? Thank you to our IT crew. All right. We're adjourned. All right, thank y'all.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.